The committee will be in order. Good morning. Welcome to the Joint Legislative Committee on Government Oversight. Apologize for our late start today. It happens every once in a while. We will have committee introductions. We don't have anyone joining us on on Zoom, as far as I'm aware. So we'll start to my left today with Representative Eater.
Good morning. Good to see you all on this hot day. My name is Representative John Eater. I represent Alfred, Lyman, and Waterboro.
I'm Michael Lemlin. I represent House District 53, which is Chelsea, Randolph, Pittston, and Dresden.
Morning, Representative Chad Perkins. I represent 7 towns in southeast Piscataquis County, which make up District 31.
Senator Garrett.
Good morning. I'm Senator Stacey Guerin. I represent all of Piscataquis County and 11 communities in Penobscot County, District 4.
Good morning, folks. My name is Brad Fair, and I live in Norridgewock and represent Senate District 3.
Good morning. I'm Senator Jeff Timberlake. I represent Senate District 17.
Madam Chair.
Good morning. I'm Anne Marie Mastracchio. I represent House District 142, which is part of the city of Sanford and the village of Springvale.
And I'm Craig Hickman. I represent 12 municipalities in southern Kennebec County, also known as Senate District 14. Turning to the summary of our last meeting, held on March 27th, 2026. It's been a minute. Members will see this draft document in the meeting binders. And further, if there are no comments or proposed edits, that summary is considered final. Seeing no objection, it is so. We invite Representative Collins to join us at the microphone so she may present her letter, also signed by 22 other of our fellow legislators requesting a review of certain safety concerns in the Maine prisons. In this regard, the chair also notes for the members that in this same meeting tab in our binders, just behind the letter, is a copy of a complaint recently filed in federal court, which may be relevant to the committee's deliberations on the matter. And so with that as an introduction, we welcome you, Representative Collins, and you may proceed when you are ready, and then the chair will see if there are any member questions. Welcome.
Thank you. Good morning, Senator Hickman, Representative Mastracchio, and honorable members of the Committee on Government Oversight. My name is Alicia Collins. I represent the towns of Sydney and Vassalboro in Maine House District 61. I'm grateful to the members of this committee for hearing testimony today in relation to concerns at the Maine Correctional Center in Windham, specifically the Women's Center. During my testimony, I'd like to address why I'm before the committee, my understanding of current law, and request the committee find ways to implement corrective actions on behalf of the residents incarcerated in Maine. In August of last year, myself and several other legislators had the opportunity to tour the Maine Correctional Center in Windham, including the Women's Center. While we were there, we observed one biological male housed with female residents. We asked our tour guide, Warren Ben Beal, about issues of violence, rape, or privacy housing men and women together. Warden Beal assured us the prison took these issues seriously, and any allegation is thoroughly investigated through the guidelines set up by the Prison Rape Elimination Act, PREA. We took Warden Beal at his word. In February of this year, a letter was sent to multiple news outlets about a situation of abuse at MCC. 2 news organizations did stories on the content of the letter. One news outlet published the letter, and the other spoke to inmates. Both reporters attempted to reach officials at the prison, but the officials refused to discuss the allegations, citing privacy regulations. The letter was written by resident Katie Mountain, alleging harassing and abusive behavior from her cellmate and bunkmate, a 6'1", 310-pound, fully intact biological male. Let me quote parts of her letter I found disturbing. Her roommate told her, "Sorry, I can't help you, but I can put a baby in you." And Katie wrote, "I was scared because my roommate was sitting at the top of my bed, just staring at me while I slept, and then would make comments like, 'Don't worry, if you don't wake up, I smothered you with a pillow.' Or thinking it's funny saying, 'Mountain, want to murder that light for me?' Katie's roommate, Andrew Balser, was convicted of murdering his parents and the family dog, a Chihuahua, with a hunting knife. Katie also wrote about an encounter with her roommate in the bathroom. He wanted to read some of the stories he was writing for me. I came to find out it was a sex scene. Things got awkward. I jumped up to get out of the door, but I wasn't quick enough. He pushed me back to the wall and kissed me. I turned so my nose and cheek, then pushed past him and ran. Having been the victim myself of physical abuse encounter, where the only safe place for me to hide was a locked car in the heat of summer, and we can relate to that today as it is so hot. I have a serious issue with a biological male making offhanded threats and physically touching another resident, a resident that has no place to hide. Katie claims she talked with the sergeant on the desk about being moved to another quad. She asked the unit manager to be moved. She was warned by the other women not to say anything, writing, "Be very careful that what I say, because it would be me they lugged off to SEG if I express feeling unsafe." And that is just what happened. In March, the representative from Phillips, Mike Sobolewski, and the representative from Palermo, Katrina Smith, and I visited Katie Mountain. She was indeed in segregation with no privileges, no library, no gym, no commissary, locked down in her cell. She told us she was having trouble sleeping because of her experiences with Balser. Not mentioned in the letter was his proclivity to sitting in a chair next to the head of her bunk while she slept. He would sit there and stare at her and sometimes stroke her hair. The day we met Katie, she talked about having 9 weeks left of her sentence. She was relieved to be away from Balser. She felt safer. Katie has asked for help and none has come. In fact, she has been in segregation because of her complaint. We also had an opportunity to speak with resident Jennifer Albert about her experiences at MCC. She has witnessed Balser telling sexually inappropriate jokes. She has woken to Balser sitting at her headboard, stroking her hair, and had him say, "You're so beautiful, I just want to kiss you." She has seen him rub his erect penis through his pants, and she has had him rub his crotch against her. Jennifer Albert believes Andrew Balser is a predator. She's filed 4 grievances against Balser, but has received no follow-up or explanation about her complaints. She and Katie both claim they've been told by officials, "We're just following the law, and if you don't like the law, call your representative." Jennifer Albert does not believe anyone will protect her or the other residents at MCC. I will note we attempted to set up a meeting with Balser. However, we were denied. The department cited policy 21.4, procedure E, section 3, which states that a professional visit will not be approved if allowing the visit would create a risk to safety, security, or orderly management of the facility. I wanted to understand why a predator was being housed in the women's unit, someone so dangerous that 3 legislators were denied visitation, and why nothing was being done to protect the other residents. A FOIA request was sent to Commissioner Liberty in March to get clarification on the department's procedures on housing policies, on protecting residents from abuse, and to find out the number of complaints of harassment at MCC. I received a response to the FOIA request. The Department of Corrections could not answer all of my questions due to statutes on confidentiality, and cited its own policies, PREA, and Title 34A, subsection 3031, section 10, to justify housing this person among other residents. An annual PREA report was included with the FOIA and showed a disturbing increase of 400% of substantiated claims between 2023 and 2025. Claims like non-consensual sex acts, abusive sexual contact, and sexual harassment. These numbers have made me concerned that the Department of Correction is not doing all within its power to protect the residents housed at MCC. Currently, an incarcerated person still has rights and protections under the law. Protection from cruel and unusual punishment under the 8th Amendment. The Code of Federal Regulations, PREA, subsection 115.13, requires that each facility protect inmates against sexual abuse. Maine State Constitution, Article 1, Section 9, protects against cruel and unusual punishment. Title 34A Maine Revised Statutes 3031. Any person residing in a correctional or detention facility has a right to, Section 6, protection against physical and psychological abuse. The Department of Corrections' own policies, 6.1, 6.11, 20.1, and 23.8 have language regarding sexual misconduct and sexual harassment, sexual touching, and safety of other residents. The Maine Department of Correction has a duty to protect its residents from abuse. However, it appears that that is not happening in Wyndham, and the department is using privacy rights and citing their own policies to justify housing a predator with other residents. Please, I encourage the Oversight Committee to find a resolution to protect the residents at the Maine Correctional Center in Wyndham and direct the Department of Corrections to provide a plan of action to implement that resolution in a timely manner. And I thank you for your time today. I appreciate you guys very much for seeing me, and I'll be happy to answer any questions that you may have.
Thank you, Representative Collins, for presenting this letter to us. You initially drafted the letter on March the 9th, and it's been a few months. Are you aware of the complaint that has been filed in federal court dated May 9th, 2026?
Was that from her attorney?
Yes, ma'am.
Okay, yes.
Okay. Are there any questions from the committee? Chair recognizes Representative Peter.
Thank you, Representative Collins, for raising this issue and bringing it before us. Several times throughout your letter, you use the word abuse. And within the department, have you come to understand what constitutes abuse? How is abuse defined?
So I appreciate your question. Thank you. If you look at Title 34A in the Section 6 of subsection 3031, it just says protection from abuse, physical, or, forgive me, I'm a little nervous. But what I found as I looked through the whole section, Title 34A, is there's no actual definition of what abuse is. In PREA, there are definitions for abuse, but specifically sexual abuse. So I just found that like alarming. If I was a corrections officer, how do I define abuse? So thank you for that question.
And Representative Collins, have you reached out to anyone on the Criminal Justice and Public Safety Committee with these concerns?
I suppose I have not.
Okay.
Thank you.
Chair recognizes Representative Perkins.
Thank you, Mr. Chairman. If I may, I just have a couple quick related questions. You said that, or in your letter here, you said that she had 9 weeks remaining on her sentence. To your
Yeah.
knowledge, is she still incarcerated or has she been released?
To the best of my knowledge, she is still there.
So, okay. So since, since she's been in ADSEG, has she been eligible for any kind of early release or community confinement, or has that been denied because she's been in ADSEG?
To the best of my knowledge, those things have been denied.
Okay, and you mentioned that there was the annual PREA report. Was that just for the women's facility or for all of DOC?
It was all of DOC. I
You-
focused primarily on the women's facility.
Okay, so when you say you focus primarily, is that 400% that 400% increase? Is that a 400% increase DOC wide or just in the women's? facility?
Just in that facility.
Thank you.
Thank you. Are there any other questions? Chair recognizes Senator Timberlake.
Thank you, Mr. Chair. And thank you, Representative, for being here. I guess as I was doing some research and looking through what you submitted to us, and there's something that has stood out to me, and I just wanted to understand if it's really, as the way I read it in the report there, and also with what you submitted on page 1, 2, 3 of your thing. You put she was indeed segregated with no privileges, no library, no gym, no commissionary, locked down in the shield. She was told she was having trouble sleeping because of stress. Am I to believe, and are you to believe, that this happened because of her complaining about her cellmate?
In my opinion, I do believe that is true. And I will tell you, when we met Jennifer Albert, the same day we met with Katie, Jennifer talked about being able to take her things from segregation and go back to general population. Once she received the freedom to go there, she was approached by one of the corrections officers there and was asked to apologize to resident Balser for not using the correct pronouns for her. And she refused to do that and was sent back to segregation. I think there's a environment there that the corrections officers may be fearful because of gender ideology, but I can't speak to that. My biggest concern is when someone has a problem with being sexually harassed, those concerns should be heard and investigated. Because of the privacy component to the inmates, we did ask for authorization for disclosure because the Department of Corrections continues to hide behind privacy. That complaint or that disclosure was signed the day we were there in March. It was handed in the following Monday because we wanted to make copies, and those records still have not been sent to us, even though both inmates signed them. Within those records would be the grievances and other things to be disclosed. So without having more specific information, I do believe that they are in segregation because they are being harassed, and it's easier for the corrections officers to simply put them in segregation than have to hear the grievances. That's my opinion from what I've obtained for information, the limited information I have.
Thank you. Follow up.
You may proceed.
Thank you. So as I listened and as I read, did you have a conversation at any time with anybody with the department of why Mr. Balser was even allowed to be in the same room? Why couldn't they at least put him in his own cell?
So
Was there any explanation of why they even had to? Because I didn't think they was overfilled there.
I will say my personal conversation with Jennifer Albert, she brought up the fire department in inspecting the Wyndham facility and the firemen telling the corrections officers that there were too many people housed in the units. They're quads for a reason. There should only be 4 inmates per unit, and they're actually housing 6 at a time. And once they moved the units back to 4, and then once the fire department left, Resident Albert told us that they put 2 more beds back in the quads. I don't know if that actually answers your question.
Yeah. No, I just wondered if you, in your conversation that
Yeah.
you'd had with the department, if you'd asked if they could come up with something for a different solution, did they offer up something, for every problem, there is a solution.
Yes.
And I wondered if when you asked the question, if they look for one, because as I read this, it looks like the only one that's getting punished here is draw blank on her name, is Katie. And he's not being punished. And she's only being punished because she filed a complaint.
Right.
And I just wondered if, to me, it would have been simpler for them to shuffle people around or do something. And I
So
wondered if you had that conversation with him while you was there.
I know Representative Sobolewski has had that conversation with the Department of Corrections. I don't believe that he has had an answer as to why they couldn't just do that. I do know in some of these policies that I have read through that transgender individuals are not supposed to be housed in individual, this is my understanding of the policy, in their own individual quads. And I don't know if that is part of the reason. I was hoping the commissioner or even the warden would be here today to maybe answer more specific questions for the committee.
Do you know any idea if that would be because I Because that would make sense, so they wouldn't do it.
Uh,
Sorry, that
yeah,
was a
that's-
comment you didn't
I
make.
can't speak to that. Thank you.
Chair recognizes Senator Gary.
Thank you for coming and bringing this important issue, Representative Collins. I appreciate that. You shared with us a number of incidences reported by Katie Mountain that would be considered sexual harassment under the standards that we have to live by as legislators. Clearly, they would be disciplined for those
Right.
actions. Is the Department of Corrections saying these incidences reported by Katie are false, or that they don't consider them sexual harassment?
So that specifically to Katie or Jennifer, again, the department is standing behind privacy and won't speak directly to that for those individuals without the authorization for disclosure, which they do, which the department does have. And at this point, Representative Sobolewski has filed a FOIA to motivate them to get that information back to us. Yeah, thank you.
Are there any other questions from the committee at this time? Chair recognizes Representative Peter.
Thank you. I have another question. I don't know if you know the particularities of this, but at what point did this man begin to identify as a woman? Was it after sentencing? Know the background of that?
I don't, and I don't know if it's relevant to my current concerns. So I can't speak to that, but thank you for asking.
Are there any other? Chair recognizes Representative Lemlin.
Thank you, Senator. Good morning. Has anybody spoken directly to Commissioner Liberty about this issue?
I saw Commissioner Liberty a couple of weeks ago, and I thanked him for answering my FOIA request. And he said, sure, we're working for the people. So that's been my conversation.
But nobody's asked him questions about it or,
I do believe Representative Sobolewski has had a conversation with him. I don't know the information that came back out of that.
okay, thank you.
Are there any other questions for Representative Collins? Chair recognizes Representative Perkins.
Thank you, Mr. Chairman. Thanks, Representative. You may not know the answer to this, but since you were in the facility and you've met with these inmates, is there more than one, other than Balser, is there more than one person who was born biologically male that now identifies as female located in that same unit or in that facility?
Thank you for that question. Per Jennifer Albert, there is at least one other. Jennifer Gingrich is another party that has spoken with inmates over extended period of time. She believes there's at least 3 trans people that identify as female in this facility. Jennifer Albert states that one of these persons is actually in a relationship with one of the women in the facility, and that isn't Balser. We did ask Jennifer, you hear stories on, TV about inmate rape and whatnot. Are there women in this facility that you're concerned with, like you may be concerned about Balser? And she indicated that, yes, there are fights that break out. And she said, typically what will happen is we just avoid each other and move on. It's kind of like a schoolhouse, fight. But she said with Balser, he is insidious and predatory in how he approaches women and what he says to them. So the other inmate that's in a relationship with a female, they didn't have any complaints about, or Jennifer had no complaints about this particular individual. So I don't know if I don't think the transgender issue plays into this. I think the abusive behavior, the sexual harassment that we as legislators took a prevention class on one day this past session, we were trained to say, you look nice today is a form of sexual harassment and how it's stated. One of the statements from Katie Mountain is Balser throwing a tea bag at her and saying, "I teabagged you." And he's thinking that this is funny behavior and no disciplinary actions are taken against him. Again, I have serious concerns about his behavior in how he's treating women in the facility. And complaints are made to the sergeant on the desk, the unit manager, and no one seems to be taking these complaints seriously.
So on the reverse side, are you aware of any people that were born biologically female who now identify as male that are in the facility?
There is one individual that I am aware of that is in the facility who identifies as a male. And again, that's just from some of the articles that I've read.
But they're in the female facility.
They
not the
are.
Male facility.
Yeah, they're in the female facility.
Thank you, Representative. Are there any other questions from the committee? Seeing none, we appreciate you being here today.
Thank you guys enough
To
for
us.
hearing this. Thank you.
So the committee can consider what to do about the questions that the lawmakers have presented us with. Since the letter, and even before today, after we planted the agenda, we have in our binders a United States District Court, United States District Court, District of Maine. There is a federal complaint. First Amendment complaint demand for jury trial, declaratory and injunctive relief. I'm certainly not going to read the entire thing into the record, but I do want to point out the introduction. This case challenges the constitutionality and application of a Maine state law. 34A MRS Section 2008, paragraph B, subparagraph 3, and related policies that require the Department of Corrections, DOC, to affirm the gender identity of convicted murderer Andrew Balser and several other violent men by housing them in the women's facility at the Maine Correctional Center and forcing everybody to call them women. The law applied to female plaintiffs Katie Mountain, Jennifer Albert, Michaela Sargent, and Danielle Foster demonstrates its cruelty and the deliberate indifference to safety, privacy, and civil rights of women incarcerated in the state of Maine. It follows. I will go straight to the prayer for relief. Plaintiffs respectfully request this court to enter judgment for them and order against defendants as follows. An order and judgment declaring Maine's gender ID laws, including 34A MRS 1208, as I've said earlier, and DLC policies 1.6 and 23.8, facially and as applied to plaintiffs, violate the cruel and unusual punishment clauses of the United States and Maine constitutions, the free exercise of religion and establishment clauses of the United States and Maine constitutions, the freedom of speech clauses of the United States and Maine constitutions, the due process clauses of the U.S. and Maine constitutions, and the equal protection clauses of the U.S. and Maine constitutions. An order permanently enjoining and prohibiting defendants' liberty and bill in their official capacity from enforcing those laws and policies or otherwise interfering with plaintiffs' federally protected rights and guarantees. Judgment and award of damages, nominal or compensatory, and an injunction against defendants' liberty and bill for violation of the Maine Civil Rights Act and Maine Human Rights Act. Judgment and award of damages, nominal, compensatory, and punitive against defendant Balser for attorney's fees and costs and such other and further relief as the court deems appropriate and just. This was filed again on May 9th. I'm sure that there is an opportunity for a response that the court will put into their schedule. We don't have that in front of us. As precedent on this committee, when an individual or an entity pursues remedy in a court of law, as is the case here, the Government Oversight Committee stands by and allows that process to complete itself. Because as we know in all complaints, this is a side of the story. There will be responses to this, and then the judges will rule. Who knows how long that will take. Abusive behavior from an individual toward any number of people is absolutely a problem. And those who are managing our correction systems will face questions because of this complaint. So as is traditionally the precedent of this committee, we tend to wait that out. If there is anything else people would like to see happen, I will certainly take that under advisement. The chair recognizes Senator Farren.
Thank you, Mr. Chair. It's pretty disturbing to read the entire content of this situation. And I hear clearly what you said. I mean, as a legislator, we typically have constituents come forward, and one of the first questions we ask is, are you represented by an attorney, or is there some kind of legal action? Because to your case of the remedy. One of the things that Representative Collins talked about, though, was the department not responding to the release of the information that they had the disclosure agreements done. I think that's separate from the lawsuit, from that standpoint. And I think, I'd like to at least see the department come and explain why they're, at least, I understand the lawsuit, but if there's been a disclosure to release some of that information from individuals, I think that's separate from the lawsuit. And I think that's something that we could ask the questions of that. That's my takeaway from both.
So Senator Farren, just to be clear, you would like for us to, at a future meeting, invite the Commissioner of Corrections and or the warden to come before us and answer questions based upon this complaint?
Totally separate from the lawsuit. Understand we're going to get the Heisman stiff arm on that, but there's still some other processes in here that I think we could at least shine the spotlight on this situation and have some conversations.
Senator Timberlake.
Thank you. Senator Farren probably said it much more eloquently than I was going to say it, but I'm under that same pretense. I think that the lawsuit is about Katie and suing the state for what she thinks that how she was mistreated. I think myself as a senator and as a legislator in the state of Maine, my concern is that how is this continued to allow to happen? And why haven't the representatives who've sent letters received a response back from the department and from the warden? So I would like to see that we ask the warden and Ms. Liberty to come in and sit down and just explain to us why we haven't found a solution to this problem. Why is this still continuing? Because at the end of the day, Mr. Chair, this lawsuit is going to cost the state of Maine thousands and thousands and thousands of dollars just to defend. And I think it could have been stopped if we'd have had some response to it in the first place. And that's a part I think that bothers me, that I think we should have been able to come to a solution long before we filed a 33-page report. And so I think the lawsuit and what we're asking are two totally separate things, and I'm going to be in support of bringing them in to answer questions.
Thank you, Senator Timberlake. Chair recognizes Representative Strachey.
Thank you, Mr. Chair. I don't have a problem with asking the commissioner to come in, and as long as we're very clear and very specific. In my mind, the questions, they couldn't relate to the lawsuit, and they wouldn't be because of the lawsuit. In my mind, it's that I am looking at the Chapter 34A, Section 3031, number 10, which seems to be the place that was that this piece of the law was amended in 2021 in the 130th legislature. And I just want to be clear that passed under the hammer. It was a 12-1 report out of the Criminal Justice Committee. So everybody just be aware that this is something that was put in here without a whole lot of contention in my mind, because I looked at the testimony, I read it, because that was specific to this complaint. And so my questions would be, the policies that have been implemented around this number 10 are of interest to me, or the difficulty of implementing law that was that a legislature passed. So, and sometimes there are unintended consequences. So I would be interested in knowing that coming into the next legislature, if there are things that need to be changed, ignoring the lawsuit totally. And then the other issue is a response to a request, a FOA request. Those two issues to me would be, I would just want it to be very well defined what we were going to do, because what I don't want to have happen here is ask questions that directly relate to the case with the mentioning of the people in the case. So that's where I'm from. So if it's going to be a narrow questioning that ignores this piece of using people's names and everything, then that's fine. I will be totally in favor of that, because I'm always interested in when we pass something that we don't know what happened and how it turned out.
Thank you. Chair recognizes Representative Perkins.
Thank you, Mr. Chairman. There were some questions that were asked during Representative Collins' presentation that I actually had some answers to, and but I couldn't really say as member sitting up here. So prior to any request being sent to GOC, as a member of the Criminal Justice Public Safety Committee, I was contacted by a family member of Ms. Mountain, who is a constituent of mine. And this matter was brought to my attention, and I actually did sit down with the commissioner. And I did not get very satisfactory answers on any kind of resolution myself. So the answer to your query earlier, yes, someone has, not Representative Collins, but someone has contacted someone on the Criminal Justice Public Safety Committee, myself, and the legislature myself has sat with the commissioner. So those things have happened. As far as the testimony that we've heard today, I've given speeches at correction classes, and I always tell the young people that are, graduating class and becoming corrections officers that their primary duty is maintaining the rights and the safety of the people in their care. And I stress that. And I think that what we see through this testimony is we have a failure of that for whatever reason, whether it's a law that was changed or a policy that's implemented poorly because of the law that was changed, or poor leadership, or whatever the reason is. I think that we have that failure. And because of that, I think that we have some real victims here. And having been a detective and actually investigated sexual assaults and rapes, and I can tell you that's worse than a murder, because when you're murdered as a victim, that crime is done, that pain is done. But when you're the victim of sexual assault, you live with that pain every day. And what we have here is we clearly have someone that is a predator, in my opinion. And we know that predators escalate, and we're going to have some serious sexual assaults going on here. If this kind of continue, this kind of behavior is allowed to continue, and whether Miss Mountain is in the facility or not, we have other residents in that facility that we as legislators and them as the Department of Corrections have a duty to maintain their safety and dignity while they're in our custody. And because of that, I very strongly want to hear from the commissioner, from the warden, whatever staff he decides to bring with him, to explain to us why they failed so miserably in doing so.
Chair recognizes Representative Peter.
Thank you, Mr. Chair. I also would like to query the department. Particularly want to hear about the inconsistency of how the law may be applied if the truth is that there's a woman that identifies as a man, but she's housed in the female facility. The implication there is they're trying to prevent harm to this woman who identifies as a man, and why they aren't taking the same approach in the other direction. So I for one, would like to know about the general policy and how it's being applied. Thank you.
Chair recognizes Representative Lemon.
Thank you, Senator. I'm in agreement also with bringing the commissioner in here. What this looks like to me, it's almost crystal clear that the commissioner and Mr. Beal seem to be more afraid of the people supporting transgender rights over the people supporting the other rights of sexual harassment. And I'm not sure why, but that's what it looks like to me. And I think from reading all of this that there was an easy solution and it wasn't taken. To me, if you have a predator and you have a complaint, you isolate the predator, you don't isolate the person placing the complaint in. This is 101. I'd like to know why. What are they afraid of? Because it looks like they're afraid of something. They're afraid to react, and they should not be. The law's the law. And I understand you have to protect the transgender rights and you have to protect the other person's rights. I get it. But there's a crystal clear way to do that. That's been around forever. And I don't see that that's been done here. So I definitely would like to call the commissioner and the warden and find out what's really going on behind the curtain. Thank you.
Thank you, Representative. Chair recognizes Senator Garrett, followed by Senator Tillman.
Thank you, Mr. Chair. I also agree that we need to have them come in and have a talk. And one of the questions I would like them to answer is, what are the sexual harassment or abuse standards that the Department of Correction uses in relationship to inmates' interactions with each other? If we're making a list of things to send to them. I'd like that out.
Thank you, Senator Timberlake.
Thank you. Thank you, Mr. Chair. I think I'd like to put a motion forward if it's, well, I'd like to put a motion forward that we ask, the commissioner and the warden come in and appear before us to answer the questions regarding, our questions to how this was handled and why it was handled.
There's a motion made by Senator Timberlake to invite Commissioner Liberty and Warden Bill to come before the committee to answer questions related to this matter. It's been seconded by Representative Perkins. Is there any discussion of the motion? Chair recognizes Representative Strachan.
Thank you, Mr. Chair. I would really hope that Senator Timberlake could narrow that a little bit more for me, because in order for me to vote for it, it can't be that open. I mean, I really want it to be specific to, I mean, I agree. I think Senator Garrett's question could be asked in any context. I think the questions that I had in relation to Section 10, which was the law change that I think changed the policies that are utilized. And that was a legislative issue. And so I think that we are absolutely, I would love to hear about how they implemented that policy and any issues that have obviously come out of it, if there have been. And we're seeing potentially one here. But other than that, I'm trying to think, was there anything else? Because I would really like to enumerate where we're going to narrow our questions, because what I don't want to do is have a lot of stuff that's under litigation that we don't want to, that isn't going to be on the table.
Senator Timberlake.
Thank you, Mr. Chair. I don't know as I'm gonna go to limiting it any more than what I said, because I think it's up to the chairs to determine whether the questions we ask at that time, because I really want to be careful that I don't limit it to such a factor that now we can't ask any questions of, could you have found a solution? Why did this end up there? I don't know how I could say that I only want to be able to ask these 5 questions. I'm not going to do that, because I think this is really important. And I think it's something we have to do. And so I'm not going to restrict it to that. I'm going to leave it to where I left it and leave it in the hands of the chair.
Representative Strachan.
Senator Timberlake, it really was about topics rather than questions.
I think that we have a precedent already with the situation with the Office of the Secretary of State, where unlike asking the director to scope out something, before the meeting where we are inviting the commissioner and the warden, we will scope out our questions and make sure that they know what it is that we are going to ask them when they come, and they can be prepared. And of course, if they do come, they can make an opening statement. They can listen to this and decide how much they can offer up in compliance confidentiality laws. So I don't think it needs to be specific questions have to be asked in the motion. I think the motion is that we're inviting the commissioner and the warden to come before the committee and answer our questions. Before that time, we will come up with those questions, as Senator Garrett has already put one out. You've already put one out, Representative Strachan, and there may be others that we'll ask our staff to put together for us. Representative Levelland.
I just wanted to say that I agree with the chair. I think we all know that we have to avoid the court case. And I think outside of that, we have to leave it to the chair to determine whether or not we're staying within bounds. That's my.
Senator Farren.
Ditto what you said, Chair. The commissioner or the warden will come, and if there's a lawsuit, they will decline to answer questions based upon whatever down through. And so there's the guardrails in place. I think that we can keep ourselves all out of trouble from that standpoint.
Is there any other discussion of the motion in front of us? Is committee ready for the question? All those in favor, please indicate with your name. It is unanimous. Absent members will have until Friday by noon to vote in absentia. Thank you all very much. I will request, Representative Collins, can you just turn that mic off before we move on to the next agenda? It's okay.
I wanted to wait for the right time.
I appreciate that very much. And thank you again for being here with us today. Stay cool. Turning to our next item on the agenda, we now welcome back Director Bobby Johnson of the Office of Child and Family Services to continue the committee's work session on the recent OPEGA report concerning the timeliness of child care payments for children in state custody. The chair first notes that during the OPEGA director's report later in the meeting, members will see in that binder tab the letter previously voted on, by which the chairs have written to the DAPS commissioner inquiring about email accounts that may not have certain retention features, an issue which was noted on page 23 of the OPEGA report. And with that, Director Johnson, welcome. Thank you for being here today. You may make any additional statement you wish, if you would like to, or we can just ask members if they have any questions for you while you are here today. Thank you for being here.
Good morning, Senator Hickman, Representative Mastracchio, and members of the Government Oversight Committee. My name is Bobby Johnson. I'm the Director for the Office of Child and Family Services within the Department of Health and Human Services. Thank you for inviting me here today. While I was unable to attend the previous meeting, I hope the responses that we sent to your questions were helpful. I brought copies of the March 26 memo for reference during today's discussion. I appreciate the continued conversation related to OPEGA's report on timeliness of payments to certain childcare providers by OCFS. I am pleased that OPEGA recognized that OCFS is processing childcare payments within 30 calendar days of receipt over 95% of the time, and within 7 days, 66.8% of the time. A positive finding that reflects the department's continued focus on timely processing and operational performance. We also recognize that there is always room for improvement and continue our efforts to advance the 2 recommendations outlined by OPEGA, establishing and documenting a standardized statewide process and clarifying and communicating current invoice requirements between the different parties involved in the process. The department deeply values childcare providers who deliver care for children in custody. These providers are an essential part of the system of care, allowing foster, adoptive, and kinship resource parents to work or further their education. Reliable payment practices help ensure this critical network of care remains strong and sustainable. I'm happy to answer any questions about our responses provided on March 26.
Thank you, Director. Is there any question from the committee for the director at this time? Chair recognizes Senator Fair.
Thank you, Mr. Chair. Thank you, Director Johnson, for being here. What are the questions, and I'm struggling because I'm going back through, I was just moving paper around. But from that, one of the comments that I had was a timeline and a schedule of the implementation of these recommendations. Specifically, I didn't see that those, that plan was laid out there so we could track the progress.
Yeah, so I can talk about the status of our work to address the identified issues in OPEGA's report. We have engaged with the Operational Excellence team. I'm the executive sponsor on the project, and our Chief Operating Officer, John Feeney, is the lead on the project. We are conducting work sessions in several district offices so that they can get information that builds on what we were able to receive from OPEGA about to establish a thorough understanding of the challenges and the opportunities that exist within the current process. The goal of this project is to establish clear expectations and a standardized process that will be documented in a standard operating procedure, as well as a standardized invoice template and training, on-demand training that will be available for staff that are responsible for these activities. And so we are on track. This work started, I think, back in February or March. Just check the The beginning of March, this work started, and we are hoping that it will be finished, and that we'll have a training available for staff, a standard operating procedure that will be shared for all district staff to be trained in and follow, and then a standardized invoice that we will disseminate to our providers by fall
This,
this year,
Represent-
yes,
uh,
fall
so-
2026.
all right, that's a window. I mean, as a target,
Yeah,
I mean, October, September, you don't have a definitive timeline to
I
roll
would
this out.
say by late October, November is when we expect to have these activities completed.
Thank you. Any other questions? For the director, Chair recognizes Senator Timberlake.
Thank you, Director, for being here today. I think, you know, one of the things that got us here over time is all the emails that some of us received setting up here on the committee about payments that haven't been made on time and how we got here. And we appreciate the work that's gone through, but as we read the report and go through. So can you tell me as of now where we stand with all the daycares and providers being paid on time? Do we still have some outstanding ones that aren't there? Or has everybody been paid now and are we up to date? Can you tell me where we stand on that?
I don't have that information, Senator Timberlake. We provide payment to a lot of childcare providers throughout the state. I would assume that our performance remains as it was when OPEGA did their inquiry, and any issues that are brought to our attention, we are quickly following up on, and so we can ensure timely payment and determining whether that is an issue that we need to follow up with the provider about to get an accurate invoice. It's an issue within OCFS that we need to make sure it's being processed timely, or if it is an issue with the service center or DAFs that we need to understand in order to move those invoices forward. But we are committed to paying individuals once we receive those invoices as timely as possible.
You may proceed, sir.
Great answer. But no answer. Because I want to know, and I've been trying to get to the bottom since day one that we ever started this, was that we have, and the report says that we have a problem paying our bills on time. If we've actually improved it, or are we still running on the exact same numbers that's in this report? Or are we by now almost basically a year and a half, actually, that we have been discussing this? Are we better today? And we know where the trouble cases are. Have they been all cured up and are they fixed yet?
So respectfully, what OPEGA's data showed was that we are performing within state standards 95.5% of the time and paying within 7 days, 68% of the time. Those are pretty high performance metrics. With all of the cases that were brought to our attention, the last time I was here, I reported that all but one had been resolved. And then we resolved that one as soon as we were able to.
So as of now, all cases have been resolved.
All of the cases that were part of the OPEGA review have been resolved. Most of them were resolved as soon as we learned about them, and we received the information from Director Schleck and his team about which cases had not been resolved yet.
So tonight and tomorrow morning, when I wake up, my computer screen's not gonna have me 15 people that send me a message that says we're gonna be there, because I'm gonna say, according to my records, they're all paid. They're all done.
I'm talking about a certain population of records, those that were reviewed by OPEGA. There could be cases right now, situations that there are payment issues with that once brought to our attention, we would resolve as quickly as possible.
Okay, thank you.
Chair recognizes Senator Garrett.
Thank you, Mr. Chair. Thank you for being here. I have a couple questions on your last answer. How do you track any that are falling out of the system without us having to do another OPEGA review? Because obviously we're not going to keep doing that to keep you up to date. So how will you know when you're not up to date?
So as they're brought to our attention, the ones that are not being paid timely, we are addressing those. And we do that through communication with our providers. We are also creating with OpEx a standardized process, so we will be able to track the date that we're receiving the invoice, which was an issue that OPEGA had pointed out, that we didn't have that date. And then that invoice as it processes through the system. So we're coming up with a standard operating procedure that would allow us to better know the information that you're asking about.
Do you have any like file, you put those into a computer file, the ones that have fallen out of timeliness so that you can keep checking back to make sure that they are brought current?
So if one is brought to our attention that has not been paid timely or that there are issues with, then we track that through the system until final payment. And so we have someone who follows up on that to make sure that it is being paid.
And on my question on number 5, I had asked about unique invoice numbers being attached so that it was easier to locate the correct. And I see you have unique filer client numbers, but I don't see that anything has been done about having the unique invoice numbers.
So we are, based on the dates of service, the child, and the information that's on the invoice, we're able to track down those invoices.
And that's a change from what you had done before.
That's something we were able to do before as well.
If I recollect correctly, it was stated that people were having a hard time finding the specific invoices because there was no invoice number to track it by. You had to go to the provider and the child and go through lots of different paperwork or computer paperwork to get to that point. So
Correct.
is there any intention of the department going forward to put a unique identifier on each invoice, like every business would do on invoicing?
So that would be something that the OpEx team would consider as part of a recommendation from this committee or OPEGA's report about how to easily be able to identify those without staff having to track down the specific invoice.
And is that on their work list?
I if they are particularly work list. So standardizing invoice intake workflows is part of that. And this is something I can certainly mention to that team.
Thank you.
Are there any other questions for the director? Chair recognizes Senator Blake.
I think it gets back to where I was at. If you look on page 23 of the OPEGA report, of other considerations, it goes into a little bit what the senator was just talking about. Well, outside of our scope, OPEGA would like to make the committee aware of additional areas of consideration as we work through Maine IT to obtain emails, necessary analysis, and learn that the generic email accounts established by the Office of Child and Family Services are free shared mailboxes. Unlike paid accounts, these do not have legal hold feature, which means that emails deleted from the shared mailboxes cannot be recovered beyond 30 days upon learning extra upgrade account. So the conversation, as I remember of it when we was having this, was these emails are being deleted from the Office of Child and Family Services. And I was trying to look back at here anywhere where it says that we fixed that and that's no longer happening.
We have fixed that. As soon as we learned about that issue from OPEGA, we worked with the information.
So that's never happened again since.
It should not have happened again since we had the email inboxes upgraded so that they would, so that those, any emails that have been deleted would be able to be retained in the future, recovered in the future.
Okay, thank you.
Thank you. Any other questions for Director Johnson, Representative Strachan?
Thank you, Mr. Chair. I think that you've corrected a lot of things based on the information, the helpful information that I think that OPEGA was able to give you. What I guess, I'm not going to be here in the next legislature, but if I was sitting here, I would want to follow up on this. And at some point, it might be really helpful for everybody I always like to see if what we did actually worked. So that there might be a point in time where you do the same on a smaller scale, take invoices and do like a small evaluation because I think it's great to do a report and I plan to move to endorse this report but I would think that follow up on it is just one of the many things that's integral to the report and not just let it sit there and because there will be a change in administration, but these kinds of things are the things that need to follow the whole process through. So I want to thank you for the work that you've done and taking the initiative to implement things as you went along. So thank you. And I look forward to hearing how it's working in the future.
Thank you, Representative Mastrocchio. And I would also just say that internally, we would do our own quality assurance on this because we want to ensure that the changes that we're making are resulting in the intended outcomes. So we would also do something similar to what OPEGA had done in order to make sure that we made the right changes in the system to support staff, providers, children.
And the committee may ask you to come back and share with us how it's going at any point in the future. It'd be like 6 months, it could be 9 months, it could be a year. But this report certainly pointed out great things and areas of improvement. Sounds like you're working on that. And Senator Guerin said we won't necessarily do this all the time, but we could, because this is important. This is where the rubber meets the road. So we'll have to see how it goes. And we look forward to having you back to share with us the improvements that your office has made. Are there any other questions for the director? Seeing none, thank you very much for being
Thank
here
you.
today. Chair would now entertain a motion to accept OPEGA's report on the timeliness of child care payments. Representative Strachio.
Thank you, Mr. Chair. I'll move that we endorse the OPEGA report on timeliness of child care payments for children in state custody.
It's been moved. Is there a second? The motion is to endorse the report. There is no second. The chair doesn't make a seconding motion. The law says we may endorse in part or not endorse the report. And so if we're not going to endorse the report, we'll just leave that where it is for the time being. Next, we will continue with another matter we have considered previously, namely some concerns about aspects of contract administration in the Department of Health and Human Services. At our last meeting, we heard from some providers in the community, and members will also see in Binder Tab 4 testimony and letters received from concerned providers on this matter. We now have an opportunity to hear from a DHHS official whom we ask to come to the microphone and please identify yourself, sir, for the record. Please step forward. The chair understands the department was provided with copies or had access to the essential substance of the letters and statements of concern discussed at our last meeting. You are now welcome to make any opening statement you wish to make, and the chair will entertain questions from the committee. So gentlemen, please introduce yourselves, turn on the mic, and we'll be happy to hear from you.
Sure, I have just submitted a letter to the committee. I'll be reading that as testimony, and we can proceed as you wish with questions. Yeah, it's okay. So Senator Hickman, Representative Mastrocchio, and members of the Government Oversight Committee, thank you for the invitation to appear before you today to discuss DHHS contract administration. I am Todd Haber, Acting Deputy Commissioner of Finance for DHHS. I am joined by Jim Labatoski, the Director of Contract Management. We prepared a few opening remarks and additional information to help inform the committee on this issue. Then we are prepared to take some questions. The Division of Contract Management within the Department of Health and Human Services serves as the central hub for procurement functions across DHHS programs and offices, and works closely with the Maine Department of Administrative and Financial Services Office of State Procurement Services, which provides statewide procurement oversight, review, and approval functions. This shared responsibility helps ensure procurement processes are compliant, transparent, and consistent across all state agencies. We appreciate the opportunity to provide information and answer questions you have about DHHS procurement generally, and in response to recent communication that the GOC has received from vendors.
The department recognizes the concerns raised by providers and partners regarding contract timelines, communication, invoicing and payment processes, administrative complexity, and the operational and financial impacts these challenges can create for organizations delivering services across Maine. At the same time, staff across DHHS continue to work diligently to manage a high-volume, complex procurement system. Feedback from providers and partners continues to inform ongoing efforts to strengthen processes while we maintain high standards of quality, integrity, and accountability. The operational realities of the state's large and increasingly complex procurement system are important context for these ongoing improvements and discussions. DHHS has over 1,300 active agreements. In support of those agreements, DCM oversees the processing of more than 2,200 documents, which are new contracts and amendments annually, and the payment of more than 13,000 invoices annually related to those contracts. Contract document volume has steadily increased from an average of 1,550 prior to fiscal year 2020 to approximately 2,100 from fiscal years 2021 to 2025 to more than 2,200 in the current fiscal year. This increase reflects growing complexity, scale, and operational demands of the department, program, and services. The department and the Division of Contract Management continuously reviews its processes to identify improvement opportunities and make positive progress on encumbering contracts by the start date identified on the contract. The majority of the department's contracts have a start date that coincides with the beginning of the state or federal fiscal year, July 1 or October 1. Of the department's contracts, 50% have a July 1 start and 70% have a start date between July 1 and October 1. The July 1st contract start date is meant to coincide with the start of the state fiscal year and available state funds after the legislative budget process, but it does result in periodic bottlenecks. Presently, the department is ahead of the previous fiscal year in progress to encumber contracts for the start of the next fiscal year. While volume and complexity have increased significantly over time, the department has continued to implement operational, staffing, and technology improvements designed to strengthen quality, improve timeliness, reduce backlog, and support continuity of services. The chart indicated at the end of the testimony shows the volume of in-process documents for the past several years. The spikes are the July 1 peaks. The volume peaked in 2024, reaching about 1,000 documents. The chart also shows that the peaks in 2025 and 2026 are lower. Even though the volume of contract documents has not decreased, changes discussed below have led to improvements in the ability of DHHS to effectively process contracts. The department recognizes the importance of timely contract execution to providers, and we understand that delays can create challenges for organizations delivering services as well as the main people who rely on them for services. While we strive to encumber contracts by their start date, there are several reasons why this may not occur. The first is volume. This has an impact on all teams that work to review contracts being put into place, primarily felt by the program teams and DCM. The impact also extends to other state teams, as many of the contracts need to be reviewed by the Office of Information Technology and the Office of the Attorney General. Those valued at $1 million or more require the review and approval of the State Procurement Review Committee, or SPRC. DAF's Office of State Procurement Services performs the final review and approves the contract to be fully executed. These reviews are important safeguards that help ensure appropriate oversight, compliance, and stewardship of public funds. Rework. There are times when a contract is going through various reviews and approvals, and changes are requested by SPRC, the provider, or by DAF's Office of State Procurement Services. When this happens, documents must go back to an earlier stage of the process and be updated. Skill set and training. Developing contracts and completing procurement documentation, such as the Procurement Justification Form, or PJF, is complicated and is only part of program staff's responsibilities. Training opportunities are available and are regularly scheduled. However, document quality and completeness can vary, leading to questions, revisions, and rework during the review process. Vacancies and turnover. Across the board, teams have been challenged with vacancies and turnover. This has impacted program offices, DCM, and other agencies. When people retire and expertise is lost, it can lead to a temporary slowdown of other staff while other staff are hired and come up to speed. Provider reviews and changes. While providers generally sign contracts in a timely manner, they can take additional time to review their contracts. From their internal reviews by their own accountant or legal counsel, they may request changes to a contract, language, or budget, creating rework and increasing the length of time to complete the procurement process. This happens mostly when the scope of work changes or boilerplate terms and conditions in Rider B or D change. Increasing requirements. The requirements for putting a contract into place are not static. While the basic process is fairly consistent year to year, the enhancement of forms, the additional scrutiny and reviews, and the addition of other supporting documentation all increase the amount of work necessary to get contracts in place. These requirements are important for preventing fraud. They improve the quality of contracts, increase the accountability of providers, the accountability of the department, as well as the audit trail for the department for transparency purposes. As part of our commitment to addressing these challenges and improving efficiency for the department, vendors and clients and the department and DCM have implemented a number of changes to strengthen and streamline internal procurement processes. Please note that CADB is the contract allocation database used for tracking a contract from the time it is submitted to DCM to be processed through the approval and signature processes with DHHS, SPRC, and the provider. To the time it is finally encumbered with funding, which is fully executed with the DAF's Office of State Procurement Services. First is funding line upload feature. This functionality is available for new contracts and allows funding line information from CADB to be uploaded directly into Advantage, which is the state accounting system, eliminating the entry of roughly 100 data points per contract and several hundred entries for contracts with multiple funding lines. Reducing manual entry also reduces the potential for errors. This feature has improved process efficiency significantly and reduces the potential for errors. DHHS is working with DAFs to expand this functionality to additional contract types where feasible, such as delivery orders. Generated signature page and grant award notifications. For contracts and amendments, the signature page of the document is now automatically generated from CADB, eliminating the entry of 24 data entry points per contract. For subrecipient contracts, federal grant information is generated to be an attachment for contracts. This is required by 2 CFR 200. Each manual entry creates the chance for errors. This feature improves efficiency and reduces the chance for errors. Shared queues. DCM implemented shared work queues for contract administrators and contract managers, along with standard operating procedures. Previously, work was assigned by provider, and the process left challenges that needed to be addressed. Priorities were not always handled in the correct order, unbalanced team workload, leading to morale issues and challenges in getting work processed timely. And without standard operating procedures, it was hard to shift work between members. So this has been a response to and standardizing the priorities within contracting. Fast track queues, these allow smaller and quick hit items to be processed quickly without being lost by the reviews and processing of standard contracts. Contract work that is part of fast track queues includes Advantage work and staffing delivery orders. 2-year contract length. DHHS moved to a 2-year standard contract length for many types of contracts with alternating start years. The goal was to help address the high processing volume around July 1 while balancing between each fiscal year. Template contracts. A template contract is used when DHHS has contracts with a number of providers to perform the same service. For example, DHHS has a number of contracts with providers to support main care services for individuals who are not eligible for main care and are uninsured or underinsured. These are processed as a group instead of individually, which drastically reduces the review and approval times, and it ensures the contracts end up with the same language. Template groups range from 2 contracts to over 30. Over 40% of DHHS contracts are part of a template group. Multi-vendor agreements. These agreements are a special type of template group that share the same allotment or pool of funding in Advantage. The main benefit is that these eliminate amendments to shift between providers. Over the past years, number of multi-vendor agreements has significantly increased. Many of these have July 1 starts, roughly 20% of the July 1 volume. To better distribute workload and improve processing efficiency, DHHS is undertaking an effort to shift the start dates to January 1. Additionally, because many of these agreements remained on one-year contract terms, the department is moving to a 2-year standard contract length for these. This change in process with many amendments, including in the current year. Due to this being in process now, we're not likely to see the benefit of this until fiscal year 28, when we start encumbering contracts for that year. But as you can see, what this is doing is smoothing out the volume to make it easier for, to make it easier for the department to process. Separate areas of expertise. DCM implemented specialized teams to focus on specific areas of procurement lifecycle. They include competitive procurements, which is RFPs and RFAs, contract processing, invoice processing, and subrecipient financials processing and contract budgets. These teams allow DCM staff to focus on and become expert in key processing areas and improve quality reviews. Staffing stability, the ability of DCM to support this work is directly tied to staffing capacity and stability. While staffing constraints have persisted and continue to present challenges, efforts to improve staff experience and retention have contributed to greater workforce stability, improved processing, and reductions in backlog. And you're seeing that as part of the chart at the end. Beyond these specific initiatives, the department continues to evaluate additional processes and technology improvements, as well as workload balancing opportunities to improve efficiency and responsiveness for both internal and external stakeholders. The department is committed to continuing to review its processes to meet the expectations of our internal stakeholders and external providers, while continuing to strengthen accountability, efficiency, and customer service across the procurement process. We have reviewed all of the letters provided to us from the committee and understand that there are concerns about the timeliness of payments. We will continue to consider this feedback as part of ongoing efforts to improve processes and operations. Timely contract execution is critical to supporting continuity of services for Maine people and the provider community that delivers those services. General themes the department will review: ways to improve communication and the experience when questions are received. While the shared email will continue, the department will implement a more effective process for responding to questions and escalating issues as needed. Ways to improve transparency, including how different teams within the department review contract budgets and ensure alignment with grant requirements. Ways to alert providers when boilerplate contract terms have been updated, primarily in Riders B and D. The feasibility of a portal where providers can see the status of an in-process contract or amendment, potentially submit invoices and other reports. The ability to provide regular training for providers beyond the technical assistance sessions currently provided. We'd appreciate the opportunity to provide this background and look forward to answering any questions that the committee has.
Thank you, Acting Deputy Commissioner Haber. I appreciate you putting this together and responding thoroughly to the concerns that we have received and that you have read. My initial thoughts are, I'm still confused about how this all works. And I wish I had a question to follow that, but boy, is procurement complicated. Why is it so complicated? I guess is the question.
So I can start, but there's certainly a balance between having requirements and contracts to oversee the service delivery, but there are also a lot of requirements and contracts related to compliance with federal regulations, state regulations. So certainly there is quite a balance. And so there is quite a lot of oversight and process that is layered on to contracts in order to meet all of those needs and requirements for compliance and service delivery.
Thank you. Chair recognizes Representative Stover, and please introduce yourself. I did not see you walk in. Representative Stover.
Thank you, Mr. Chair. Good morning. My name is Holly Stover. I represent House District 48, including the 6 coastal towns of Boothbay, Boothbay Harbor, Southport, Edgecombe, West Port Island, and South Bristol. Thank you.
Welcome. Good to see you.
Thank you. I do have a question. I just want to go back to, I fortunately do understand more of this than since I worked in the department, so, but I do have some questions about July 1st contracts, October 1st contracts, and then and the impact. They're separate things, but the impact that quarterly reports have on timely contracts, because if, in my experience, if someone is late with their quarterly reports, it unbalances the whole thing, because you can prepare a contract, but to sign a contract for the next fiscal year for somebody who's essentially in arrears at complying with a quarterly, you wouldn't be able to sign and encumber a new contract till that current contract is in good standing, correct? Typically,
Thank you.
For clarification, the quarterly reports that you're talking about are they our typical subrecipient quarterly reports, or are they the ones?
You're raising
provided- Oh, sorry.
Can you please raise your voice?
Yeah,
just a
sure.
bit so it's hard to-
For clarification, these quarterly reports that you're mentioning, are the DHHS subrecipient quarterly reports?
yes, when,
Okay.
when a contracted provider doesn't provide their reports to you in a timely way, which can happen for a
Yep.
variety of reasons. Somebody quits, somebody forgets, somebody,
Sure.
whatever. Isn't it, wouldn't that be a reason why you wouldn't be executing a new contract until that current contract is brought up into,
Not.
like, we need your
yeah.
quarterly report in order to proceed with your next contract?
Sure. I mean, not typically. I mean, it has been used in the past where if a provider has been tardy in submitting their reports from a previous contract, we may have language in the contract that maybe holds payments until the provider gets up to speed. You know, that's, you asked Senator Hickman, you know, what are the reasons or the things in contracts that makes it so complicated? We need to ensure that there's language in there to hold providers accountable to, so that they can take action in case something like that happens.
I have a couple of, then July 1st and October 1st. Do you have sort of a benchmark date? I'm just gonna pick one out of my hat, April 15th. Like for somebody out in a office, I'll just pick OFI because.
Sure.
OFI, like you need to have your contracts to us by May 1st or October or April 15th in order to guarantee that we're gonna have this ready by encumbered by, ready and then encumbered are very different things. You can have a ready contract, still gonna get encumbered, right?
Sure.
Do you have dates for July 1st and October 1st contracts?
We do. We have a regular schedule that we communicate to the different offices within DHHS. And it's actually a little bit staggered, right? So those contracts like that are subject to SPRC review that are $1 million and more, we know those will take longer to flow through the process. So we actually require them or ask the program offices to submit them by the end of March, right?
Right.
April 1st, essentially. So that way they can take long. Then the next step is the next highest priority or like the template contracts, so we can get more through. And then finally the remaining contracts by the end of April. And for the most part, since we've established that, the department has been pretty good in the following and meeting those timelines. And again, volume becomes the challenge, right? That's, as mentioned in the report, the volume is the biggest thing because there are too many to submit timely.
Thank you. I just wanted to clarify that around the dates. It's really important to understand that it starts really early and then they all come into the funnel, right? You pour everything into the funnel and then here's the funnel that comes in. Then everything's got to get encumbered. And I personally can remember physically running from across the street to this side of the street to get some encumbrance because I had to have them encumbered
Yes.
in order to proceed with July 1st payments. So thank you.
Thank you. Are there any other questions? Chair recognizes Representative Perkins, followed by Representative Levelett.
Hey, Mr. Chair, me and this microphone are not gonna get along.
I didn't hear what you said, sir. We all have to speak a little bit louder today. I think we're in like hot summer hush mode.
Thank you, Mr. Chairman. Thank you, gentlemen, for being here. So I also picked up on the word complexity, which you used quite a few times in your very well presented report. I mean, I can understand the complexity of contracts because of oversight and, you know, especially external demands that are put on us by, we're using federal money or what have you. But one thing I was curious about, and I might know the answer, but increasing complexity. Why do we have a constant increasing complexity? in these contracts, and how does that affect our timeliness in the payments?
So I can certainly take a start at that. The requirements from both the state and federal government do change over time. So there are increasingly new requirements that come down from or come from the federal government, or as far as oversight or other demands, but the same is true for the state. So there are quite a few compliance issues. There's complexity with new programs that come online, new requirements that need to be put in place. Certainly as new technology has come online, we're certainly, those contracts related to technology have new requirements as well. So that's part of that, if you want to add anything.
Yeah.
On the state, go ahead.
I was just gonna say, the only thing I'd add to that is, as we learn from previous contracts, right? Maybe it's areas where we weren't quite holding a provider accountable, or maybe there was something that came through like an audit. We would want to enhance the contract to add additional protections for the department, so that increases the complexity.
On the state side, you're talking about new requirements. Are those statutory requirements, regulatory requirements, or procedural requirements, or any combination of the three?
It could be all of the above.
Okay, so explain to me and the reason I'm asking is because, I mean, I can understand if most of it's statutory or regulatory, but, procedural requirements, if you're making changes, that makes it more complex and that's slowing down the whole process. I'm curious about that aspect of it. Is that a big factor? Is it any factor? Because that's something we can control here, right? Or you can control if it's a procedural thing.
So I think internally, I don't know that there has been a great deal of change. We have worked on the internal process to make it smoother.
Okay.
Most of that, what you're talking about as far as new procedural requirements may come from an external source.
Okay.
Be it state or federal.
Thank you.
Representative Levin.
Thank you. Good morning.
Morning.
Under template contracts, I'm a little confused. It says, for example, DHHS has a number of contracts with providers to support main care services for individuals who are not eligible for main care and are uninsured or underinsured. How is a provider getting paid to provide main care services to somebody who is not eligible for main care?
I appreciate that and thank you. So we can raise that distinction. So first, I'll just say that these types of contracts, within all of our contracts related to a main care service, we have language in there that says that the client member must be screened for eligibility for main care. So this is a person who is either not main care eligible or will become main care eligible in the future. So services may be delivered to them while they're waiting for their main care application. So there's not an overlap between what main care would pay versus what the department would pay in this instance. So thank you for raising that.
Okay, and so if you pay the provider, assuming that the person is going to be qualified, but they end up not being qualified, you have to go back and get the money?
So there would still be a payment under this contract. So they would just continue services under the contract on the service side as opposed to the main care side. So if they did not receive main care, they would consider to be uninsured or underinsured and would be eligible for this state service contract.
Thank you.
Thank you, Representative. Representative Stracchio.
Thank you, Mr. Chair. In our last meeting that we had 2 months ago, granted, I asked in this process if when DCM was created, was it part of the reorganization of how the state managed tobacco funds of the people that were responsible for implementing those programs? I remember when it was the Healthier Maine Partners and now it's something else. And the answer that I got, it said, they said, Mrs. Page stated, it appears that the motivation for creating DCM was consolidation of the contracts involved for better management. However, the result has created a system that it makes it very difficult for the agencies to budget, manage, and report on, as well as creating long delays. And then Mr. Letellier stated that DCM separating program people from contract people is where the system broke down, adding that communication between program and contract is critical. Because I had asked some of the people in my area if this was an issue, and I used to be on one of those Healthy Maine Partners boards. So can you respond to those? And if you agree with that? And the other, just as an addition, you mentioned staffing. I gotta find that paper, so I wrote it down. Staffing is stability. And the ability of DCM to support this work is directly tied to staffing capability and stability, which in my mind means you don't have enough. And what are you and the department and the administration doing? And what did they do to fix that piece?
Sure. I'll start with the first part, DCM was created before my tenure with DHHS as part of the consolidation of behavior and development services and human services, right? And the goal of DCM, or the job of DCM, is actually to take off the administrative burden from the program area. So for example, a lot of the improvements that you saw in this document were, administratively nature. How do we just data enter funding lines? Now we upload them in so we're not making mistakes and things like that. It's to take off that administrative burden from the program area. So all they have to worry about is knowing what to put in their contract, what they want the provider to do, and focus on the program outcomes and less upon, what happens once I get the contract written, what do I do with it next? So DCM is really taking off the administrative burden, so I think from that part, it's been effective. I know there are challenges that we face with, DCM and has faced with personnel or vacancies, if you will, turnover, just no different than the overall program offices. I think that's a theme across the board, not just focused on DCM, the vacancies or the turnover. But I guess to answer could you repeat the second part, the first part of the question again?
Well, the second question was in your note, you talked about staffing stability, and the ability to support the work is directly tied to staffing capability and stability. And while staffing constraints have persisted and continue to present challenges, efforts to improve staff experience and retention have contributed to greater workforce stability, improved processing and reductions in backlog. But is that the answer? That it's going to be what it is because we don't have enough staff? Is that forever?
So I'll answer that in two ways. So one, when you have a volume issue anywhere, whether it be a contract, whether it be at a factory, there are multiple ways to handle a situation. One is to add capacity, so add positions. So that's one. So that is one answer. What we're talking about here is how do we stabilize the current workforce that we have? How do we retain staff? How do we maintain morale so that people want to come to DCM and then stay? Having experience in handling the contract volume, handling the different types of contract documents, and developing that expertise around the different situations that present themselves during the procurement process goes a long way to also creating efficiency in the process itself. So there's really two ways to handle it. We have focused in the last 3 years have certainly focused on that retention aspect and have been successful at it. To Jim's leadership, we've been able to retain staff, but we have also looked at creative ways to hire and add capacity to that group as well to alleviate some of those bottlenecks that we've talked about.
Well, the other thing too, that's important to point out is you look at the chart on the last page, right? That's really the crux of the issue from the most of the contracts. We have these significant peaks, and years ago we had taken actions to reduce the number of contracts in DHHS to kind of shift things away from July 1, because that seemed to have been that was the challenge. And that's where some of the earlier recommendations where we split it into 2-year contracts and alternate the start years. And that did provide some relief. And that was working fairly well until, the more recent years where the volume increased. And then the problem just resurfaced with a vengeance, right? It's really what it looks like. But, that gets back to the other thing that we're doing. We talked about multi-vendor agreements, which are, these special types of agreements. About 20% of those agreements have July 1 starts. We're moving those off to like a January 1 start. And what that'll do for that chart is actually start to level out the workload. And that should provide, the goal is for that to provide a lot of relief so that we don't have this big backlog that we're trying to, or this mountain that we're trying to climb for July 1. We're kind of more leveling it across the whole entire fiscal year.
You may proceed.
Thank you, Mr. Chair. So if I was one of those vendors that was waiting for my contract or had an issue or thought that maybe the process wasn't working the way that it used to work, what's my recourse? Where do I give my feedback and how do you process that and then look at, think that they're a one of, or maybe this is an intrinsic problem with what we're doing?
Honestly, have them reach out to me and my leadership team. You know, I got a call yesterday from one of them, you know, having the same exact question, what's going on with my specific contract? And the answer that they were getting felt fairly generic. So I was, in my role as a director, I just walked them through what was going on, explained some of the details and provided more context, and was hopefully able to provide some questions and some timelines that made sense to them and that they were able to understand.
Thank you, Mr. Chair. So just to be clear, though, is that there's, I mean, you know, sometimes we think it's intuitive. Oh, why don't they just call me? I was mayor of a town. I didn't assume people, you know, for some reason,
Sure.
you know, they would maybe call me and then others might complain that, you know, I complain about something, but not call me. So where is it that you put that in words that says, hey, here's the resource for all of you because we want feedback on how we're doing and how we're working?
Oh, that's a great question. I don't have an immediate answer for you, but I'd love to find a way that works for both us and for the provider community so that they can have that opportunity to provide us additional feedback.
I find that as a legislator, it's been really helpful to be able to know that what we say actually does get out there and can be used to inform what we do. I think that it must be frustrating for a lot of those nonprofits to feel like they're complaining, but nobody's hearing them. And government is hard to change. So we changed Healthy Maine Partners and the whole tobacco, we changed that. Here we are all these years later. Might be time to take a look at it.
Sure.
Representative Stover.
I just have another question. Are you doing 2-year contracts or many 2-year contracts?
Yes.
And does
Most
that,
of our contracts, we try to target as a 2-year standard length.
and does that alleviate some of the preparation because you really have a different cycle at that point?
Correct.
I love 2-year contracts.
Yes.
Just saying.
Yeah,
I did
2-year
have-
contracts with alternating start years is really the goal.
And I just had one other question back to the uncompensated or the uninsured, underinsured and the main care question. I do addiction work and in my community. And there have been instances where I needed to access a detox bed for somebody. That's very timely. You don't want to wait because the likelihood of somebody going back out, using again, potentially dying, right? You don't want to wait. And I've had people who are not yet eligible, but I've been able to, there's certain substance use disorder detox units that will take somebody on kind of presumptive eligibility, kind of. We think we know, but we're not sure, but we have to get that done. But immediately we need this because they need to be triaged into treatment immediately. Would that be one of those instances where an underinsured or uninsured person would be getting into a facility for an emergent issue? And, you know, there was a time when presumptive eligibility was something, we don't need to go down that road, but you think like, I think I know. I think I've got a person I know, they haven't been able to work for 6 months. I know there's no income. I know that once I can get that together, but I need to do this first. Is that a good example?
That's a perfect example of what we're talking about is you're talking about presumptive eligibility, but they're not presently eligible for main care. But the provider needs to know that there is a funding source that can be utilized for their treatment. So all of that can be worked out as the contract is as invoiced, whether they become main care eligible back to a certain date. And that is able to be worked out between the provider and the member.
Thank you, because I've actually, I've dealt with different facilities across the state where that's the case. and we're able to get in the car and go and worry about that part separately. Thank you.
Chair recognizes Representative Perkins.
Thank you, Mr. Chairman. So you said the goal was to go to 2-year contracts, alternating years on with your program people, right? So I'm assuming that's just for ease of administration and cut down the workload. Is that correct?
That's the primary goal for that, right?
Okay, so if, and that's a laudable goal. I mean, I understand it makes it easier for everybody, but in doing so, would there be any kind of increased audit control or program oversight, considering that now you have to, because I can't assume that halfway through the contract, you're gonna have to revalidate some of the stuff they have to validate when they begin the contract.
So program does do periodic overviews of providers. Depending on the service type, it would vary based on that. But the 2-year service contract also provides consistency, provides a consistent funding stream for the provider as well. It creates an efficiency for us and the provider, but it also creates a consistency as far as funding stream. But to your original question, yes, there is oversight of contracted providers.
And by that, you mean who does that oversight? Now, are you talking about the program integrity unit or?
So the program integrity unit is main care. If we're talking about the service contract side, it would often be the program office themselves who do the oversight, and that certainly other staff can be involved. If there was anything related to financials, the program office can talk to our internal audit about looking at financials. And some contracts, they do provide periodic financials for that purpose. So it just depends on the type of contract and as to what type of oversight it is.
So when you say they provide oversight now in the contract, you could say they have to submit in addition to their whatever demanded, they have to provide reporting. I'm assuming each program has to provide some sort of reporting, but they might also have to be subject to some kind of additional documentation request, but that doesn't apply to every program. Is that correct?
Well, it varies between programs, so it's hard to paint with an exactly broad brush, but we also have contracts that are considered cost settled where where providers will deliver information to us, invoice information that will essentially we true up like actual service delivery with estimated service delivery, and so they have to provide that kind of documentation. So there is oversight.
Yes.
Any other questions? Nonprofits, of course, are partners to the state in providing services to the people who need them, whatever they are. My biggest concern here are the delayed encumbrance from the contract to when the money's coming in. We've got nonprofits taking out lines of credit, putting things on credit cards. That seems to be a depressive relationship with the state. And so whatever we do here, whatever we direct OPEGA to do, we have to get to the bottom of that. And yes, there's Byzantine this and meander that and oversight here at federal and state. But if we are going to rely on 2,200 nonprofits to provide services to our citizens, and there's not a consistency in how they get paid, we're failing. And I don't necessarily, you've explained a lot, but you haven't shown me the light at the end of that tunnel. Because at the end of the day, that's where the rubber meets the road. These providers need to be paid on time so they can also keep their staff and their morale high to make sure that our citizens are getting the best services they can get. So if there are no other questions for you at this time, we appreciate you both for being here and answering our questions. And I know that you take this seriously. But I do believe that the committee is going to have to discuss how better to approach this so that the folks who are needing to get paid can get paid and keep their doors open as well. So
Absolutely. And we appreciate the opportunity to provide this information to you and provided the additional testimony. The department is considered, is committed to encumbering contracts, as early as possible and on time, so that our nonprofits of the state can deliver the services we have contracted with them to do. So I hope that was demonstrated in the presentation that we are taking steps to improve the process and continue to look at it going forward. It's a continuous process improvement, so it is evolving over time, but certainly we are committed to reviewing that and making improvements as we go forward. So
Well, thank you both, Mr. Haber and Mr. Lepetowski, if I've said that correctly. I apologize if I did not, for being here today. And if we have any follow-up questions for you, we'll certainly get those to you as soon as possible.
excellent.
Thank you, Jennifer.
Thank you so much.
So the committee has now got a response from DHHS. We have seen the letters we have received. We have seen the failure of LD 1449 not get funded to do the study. When I look at that document, the duties of that working group, there were 5 duties: delays concerning the work group shall examine the state's grant and public procurement practices and make recommendations to DAFs and whatever agencies. Delays in grant or contract execution and encumberment across state agencies. Delays in payment of grants and contracts. Application, communication, or system improvements that would increase transparency, enhance communications between the state and nonprofit organizations, or improve application reporting or procurement processes. Alignment of state practices with applicable federal standards, such as the establishment of generally permissible standard of indirect costs and a mechanism for ongoing review and evaluation of grant making and procurement processes. Received another letter from Maine Association of Nonprofits on March 27th. That's in our binder. The chart that Director Schleck gave us regarding this huge procurement conundrum that we face, when we get to DHHS, on the bottom of that chart, which is right behind tab 4, is critical investment in scarce social services further impaired by potentially suboptimal contract management and administration, is a great question. I think that it is, but that doesn't mean I know how that it is. And so I'll ask the committee if we are willing to consider directing OPECA to come up with a scope of work that addresses this notion of encumbered delays in grants and contract execution encumbered across state agencies. I think at the very least, we've got to do something about that. Representative Mastracchio?
Thank you, Mr. Chair. That was going to be what I suggested, because I had also looked at 1449, which is too bad that they hadn't been able to be funded for want of $12,000. But if we don't take it on, it's just going to be further down the road. This is the only way that I see to get it so that the 133rd legislature can actually do something, if you have to do something. But if you wait and do another study group, you're just that much further down the road. New administration, I think it would be great. I guess my concern is that we have other work, and where does this fit in, and how can they do it, and what kind of, because I don't want it to take a year.
Director Schleck, can you please join us? Director, having listened to the presentation from DHHS, knowing this long history of looking at the whole scope of procurement, but now we're down to contract grant management. If we were to direct you to do a scope of work on this, can you give us an idea what you might come back with?
First of all, good morning, Senator Hickman, Representative Mastracchio, distinguished members. It is again my privilege to be with you. Happy to do just what we always do, is to come back to you as early as the next meeting, if that is the will of the committee, to put a little more flesh on the bone of what and again, not to be in love with my own question, but it does seem like there's a little more love for that question at the moment. So I'm going to take the liberty of saying I'm happy to expand on that, how we would actually go about that. But I think the core of the question is this getting in the way? I think the testimony that has been heard speaks for itself. Obviously, we wouldn't start with that as taking it just completely as true, but enough things have been said by enough people that do suggest there is a systemic level concern. And we hear again from a variety of sources that it has to do with the encumbering of contracts, the timing of getting access to the money, the running out of time at the end of the fiscal year. So there is a life cycle of those contracts that could be sort of walked through and examined.
Thank you, Director. Any thoughts from the committee? Representative Mastracchio?
Timeline? I mean, and how does that fit in with,
Sure,
give me an idea, because I think this work is really critical so that it's ready to go,
sure.
or that it's at least ready. Legislatures can do whatever they want with stuff, obviously, but I think we have a responsibility to at least provide some recommendations.
So OPEGA, as ever, remains a modest staff, but mighty in scope. And we are happy to do what the committee wants. And the committee always has the option to take a vote by 2/3 to move something ahead of something else. That's always the idea of reprioritizing. Now, I will also then say immediately, we are very much knee deep in, I should avoid my references to knee deep about the landfill, the Juniper Ridge landfill. We're in the potato fields at the moment. Those are matters that are well underway. So I would ask the committee to consider letting us finish those if at that time, and if the goal is for this year on those. As a practical matter, there is the Chelsea child protection matter that we can't work on right now, but as soon as any minute, there could be changes. I mean, if there's a plea in the case, if something happens, I'm about to tell you in the director's report about how things have kind of opened up a little bit there that make it rather intriguing. That's a matter that I know is of very high priority to the committee. There's also a matter, as we know, that the committee voted on to have us do a basically a risk assessment of the Medicare Program Integrity Unit. So that's sort of currently slotted ahead of anything on this notion. There is also the matter of somehow resolving or understanding the interplay between the state controller's perspective and the state auditor on those contracts that were in the single audit. That is something else that, again, just in terms of what's lined up currently. So we are looking into next year before we would be able to touch this, unless there's a vote by the committee to move it ahead. And I would again just mention again, Chelsea is something that once I get the clear that the court process is done, I do have the sense from the committee that that's really high on the priority, and then the Medicare item too. Medicaid, excuse me.
Representative Mastracchio?
So do you have the ability, is there a group, outside consultants doing this work and at least doing the outside, the evaluation piece of it? I mean, to me, it just doesn't seem, otherwise, let's just put the bill in that was here before and then fund it, but then you're still waiting potentially for another 2 years. So I'm just concerned that we're going to let this go. And I think this isn't as huge an issue if we address it now and it be ready for the next administration to take a look at.
I very much appreciate that. If I may, if the committee will indulge me, I can go back to my team and we can talk that over, and I can try to have a better answer for you at the next meeting if that is something that we could pull off. Consultants are always welcome. We use them from time to time for set pieces of work, especially, for example, economic analysis and the tax evaluation process. And I'm not here to say by no means would we ever do it. I'm just saying that there are times when by the time they get up to speed, there's also a bit of a lag. We are conversant in certain ways, the OPEGA way, if you will. I haven't trademarked it, but there is a process that we use, and I'm not suggesting it's so unique, but I'm suggesting that there are other considerations when deciding whether to bring in a consultant, and cost is always quite on the table in terms of what that might cost in the marketplace.
You may proceed.
I think that in light of the amount of money that we're talking about here, that's the whole point for this evaluation process that we go through, whether they're tax incentives and how government works. So
yeah,
as long as the other ones aren't in there. I mean, however we do it, I just don't want to wait. I mean, we're not going to be here for another month.
And
And I hesitate to wait too much longer past that to make a decision on this.
thank you, Representative. If you will indulge one further
Mhm.
comment, I hope the committee knows it is no lack of enthusiasm. I very much appreciate the committee's enthusiasm for taking on as many issues if we could. If only I could clone my team a little bit. You know, there's so many good issues to take on, and we just, you know, we work within the framework of Maine and modest resources, and I'm not here to question that today. I'm just saying that we have what we have to work with. We try our best to make the most of it. And there are times when we have to pick and choose. We have tried in the OPEGA process to have a process where, and I hate to put it back on the committee, but there are times where if it truly has to come at the front of the line, we can put pencils down on something and go to the next thing. That is always the sort of break the glass option. If there is something that the committee has in the fullness of time decided just really has to be the thing. The difficulty is often, and I can appreciate this, there's about 5 of those or 10 of those, and so I'm not being as helpful as I would like to be.
Well, I think that the committee, in this legislature, has just seen a lot of incoming. And some of it isn't about systemic issues, but we are here and we listen, and people believe that they can come before us and ask us to look at all individual matters. How much more room is there in your office for staff?
Well, in terms of physically,
The physical space,
well,
are you at capacity?
we generally have filled the space that we are provided, but I would suggest there is actually, as the senator probably likely knows, there's a statute where the executive branch, the legislature has provided that the executive branch shall provide space for OPEGA. So I don't doubt that if we were to be provided more staff, we would not be provided the corresponding accommodation. But I have not come forward with, you know, I have tried in my term, which is got 1 year to go. I have tried not to come to you with requests for more resources because I've tried to make the most of the resources we've had. And to date, I think we've been able to do the kind of triage. But there is this notion of the give and take, and it is difficult. But right now, I must say, I just would have to tell you, as it is, that this would have to wait unless the committee bumped it up. And then it's the question of, there's those other things that are just so high on the list. In terms of what I understand, if the committee reaches a different understanding, that's the committee, and we are here to salute and do it. So as long as just be clear, the committee decides. So.
Any other committee members have any thoughts about this conundrum? Don't be shy. I know that people have different feelings about nonprofits. That being said, they are partners with the state. So Senator Farron.
No, I mean, we heard, right, the last meeting from these groups that are doing very important work in the communities, right? And in effects, you know, and I'm not just saying that because Matt was here for Somerset Public Health, but this is an important issue. Again, it goes back to priorities. I know we're going to hear more in the director's report. There's a lot of issues and finding those priorities to the way to go through. Yeah, you know.
Well, I mean, I'm sitting here not wanting to expand the size of the legislative branch at this time. However, it doesn't sound as if OPEGA has enough people to do what we would be asking them to do.
For the detail piece,
Given that we are getting a lot of intake and it's not stopping anytime soon. And I'm not suggesting that we report out legislation. We're not in session, so we can't. But we may have to have a deeper dive with, if we were to direct OPEGA to do everything we believe it ought to do, what staff would be needed to make that happen so that we don't have to jump around and
as
because
someone,
there are a lot of priorities here.
as someone that will not be here in the next legislature, I think that's an important piece for this committee. You know, when you walk away at the end of this calendar year, when we have our last meeting in 26, that priority list with something from the director about what the requirements of the resources would be to execute it in a timely manner. That's so that the legislature can act on it. I think that'd be a tremendous deliverable for the 133rd legislature.
Representative Perkins.
Thank you, Mr. Chairman. Since I don't seem to remember, can I ask the director, what is your total staffing right now? Your total complement right now?
So, including myself and our administrative secretary and committee clerk, same person, that's 9. So, but it's also important to point out that the legislature gave us 2 dedicated analysts for tax. In other words, there are 2 full-time equivalents that by the means by which they were created, and you see them often, Carrie and Jen, they are to do tax work. And so from time to time, there's a little give and take there because it's an FTE. So there's a little movement in the joints, but essentially 2 of the 9 resources are very specific to a task. So that's something.
Thank you.
And the chair was completely failed earlier today, out of practice, and didn't even introduce our fabulous clerk to the world. Jennifer Gryden has kept the chairs in particular in line. Senator Timberlake, what have you to say?
I think we could talk about it all morning, the rest of the day, and I don't think we're gonna get to a solution. I think we're in a cycle of time right now with what's happening. We could say that we needed to put more staff, but there's no way we're gonna get money approved to get these guys more staff between now and the next budget cycle in the state of Maine. And so I think we just move forward with what we have and create the plans that we want, because the reality is we can talk about putting 6 more people down there, but we're not gonna get the money and it's not gonna go anywhere. So I think we could move on from that subject.
Well, I also think that if the committee, notwithstanding the limited resources, directs OPEGA to do something, if that list is so long that only 2 or 3 things can be done in whatever time frame, and again, this may be an off mic conversation with the director about what we have. I think that the committee ought to direct OPEGA to do what it believes should be done. If that list becomes so long that it can't get to anything for 4 years, it may be a conversation that the legislature has to have about staff. And so while we can sit here and say, well, nothing will go anywhere, how important is oversight and accountability? And it looks like from everything that we have seen here and what's going on in the world, it's extremely important. And it's becoming a headline issue, not just, oh, every once in a while something comes up and boy, that oversight committee and OPEGA do good work. Senator Timberlake.
And I'd agree with you because we sat around this horseshoe and thinking, but as someone who sat around this horseshoe for the last 6 years, I think there's a lot of administrations and a lot of departments for which the government oversight was never here and are not going to step forward to help us out in any way at any time at this point in time. I think after the next election, we'll find out what we got for an administration and where we're going. And I think we could put 20 things on the list that are very, very important to us, because there's all sorts of things that Mr. Chairman, that you and I agree on that are very, very important, need to be thing. But I don't think there's an administration at this point in time is ready to say, well, okay, they got 9 things and we want to investigate them all right now. I don't think they're going to do that. I'm going to say, we'd rather this one, in my mind. They're going to say, I'd rather this one weren't investigated, but we'll let them do these too. And so they got enough staff to do that. So I just think that's where we're at. That's reality. That's the way government works. And I don't care who's in charge. That's the way it works. And I think that's where we're at. And I don't think we're going to change that right now. I put priority in children in this for the last 6 years. And I seen how that's worked for me, and I seen how the administration and the departments are professionals at pushing back and pushing it off to always the next legislative session. And I have watched that happen 6 years of my life sitting here. And if I sound frustrated, yes, I am. I'm very frustrated, but it's a fact of how government works. And it's not pretty to watch how sausage is being made, but this is what you see, is how sausage is being made. And I think we got to pick the 2 or 3 priorities around this thing that we can afford with the staff that we got and the staff that we have, and say, these are our priorities that we want done today, or this week, or this month, or next month. And that's where we're at. And so we need to make that list and decide where we're at. And that's where we're going, because they don't want us to know the real story.
Well, I want to be clear, Senator Timberlake, that the legislature has the power of the purse. And OPEGA is an office of the legislature. And yes, the executive branch might say something about, we're just not going to fund that, but it's up to us as lawmakers to determine what we spend our money on. All of that aside, what are we going to do about this? We know it will go on the bottom of a list if we were to direct OPEGA to scope this out. What does the committee feel about scoping something out for us to consider voting on at a future meeting? Representative Stracchia.
Thank you, Mr. Chair. I would like to do that. And I would also like to ask, what's the possibility of requesting Ledge Council? They have money in their budget. And I know, I'm pretty sure that there's some leeway, because I've looked at our budget and we didn't spend all of our money, I don't think, in the past, the way that of saying we need at least a half-time person or a full-time person, and we don't have to wait until next year, like just with available resources. And is that a possibility?
I very much appreciate the question. I would tend to think that the leadership of the committee would have a role in speaking with the Ledge Council, Legislative Council, the Budget Subcommittee. There is a cycle forgive me for referencing Senator Timberlake, but Senator Timberlake has mentioned there are just practical issues about the cycle and where you get to those things. So I don't know that we will be able to engage that between now and the end of this committee. And if you will indulge me just further, and I know the committee knows this, but I'm just stating it for the benefit of anyone who might be listening. It is also a distinct possibility that there could be changes to the committee, as reference changes. It's a big year for changes at all levels of government. And a new committee might come in and reorder the priorities anyway. And so we could be doing something very differently next year. I mean, they can also vote to do just what I said, to change things. So, and we would be here just as much to say, we will do that because that is what the committee wants.
So
So,
this is the committee that's impaneled
yes, thank you.
right now. And these are the issues that we have in front of us right now. The question is, does this committee have the will to direct OPEGA to scope out this problem? Yes or no? Anyone? Representative Eater?
I didn't intend to speak, and I don't fully understand all the implications of the question. I get the part about staffing, but it is of interest to me.
Representative Lemlin? Let's just act like we had the money to do it. Would we direct OPEGA to do anything about this issue that's in front of us today?
I would be a yes.
Representative Perkins?
I'm all for OPEGA, scoping out a project for this. I'm not sure that this has to have the highest priority, but I'm not sure that it doesn't, but I'm definitely putting them to work on it.
Senator Farron? Representative Stover?
Yes.
Senator Garrett?
Yes.
Senator Timberlake?
I think it needs to be done. But I don't think it's my top priority
That's
of
not the
what we
question.
do. Well,
The question
yeah,
is-
but it is the question, Chairman, Mr. Chairman.
I'm trying to actually remove the priority list and decide whether or not this has weight in the moment. So that if in utopia, we'd have a staff, we'd have 20 people working, and we wouldn't have to prioritize anything. Is this problem appropriate for a review?
Is it appropriate for a review? Yes. Where it falls on the list is another question.
Thank you. Chair would entertain a motion to direct OPEGA, the director, to scope out a potential review of contract management across all state agencies in Maine. Representative Strachey.
So move.
It's been moved by Representative Strachey. It's been seconded by Representative Lemlin. Is there any discussion of the motion? Committee ready for the question? All those in favor, please indicate your manner. It is unanimous. Absent members will have until Friday at noon to vote on this if they wish to do so. Director, are you clear in what the motion is?
Very clear, Senator.
Perfect. So let's segue right into your report then, since you are sitting in front of us at this
Okay.
moment and we'll be out of here before lunch.
Thank you. I'll try to move along very efficiently. If the chair would indulge me in one question back, speaking on the
Mhm.
question of clear, please forgive me, I was sitting too close to that fan over there, and I just want to make sure that I heard the first motion voted on, because I think I heard having the Commissioner of Corrections and the warden come before the committee, and that in advance of that, a list of questions will be drawn up. I will be happy to be the facilitator of that. And that what we would do is circulate it to the committee. And I don't think this needed to be part of the vote, but essentially it'll be, we'll circulate it to you and say, if we don't hear from you by X date, because we fully recognize that everybody is doing many things and you might not be able, you might have something else and you don't respond to us. But we'll just try to set a timeline so that we're still having the next meeting. Am I hearing correctly that that was the vote, that there would be a list of questions in advance? Okay,
Yes, sir.
okay.
Senator Garin.
But I am not thinking that is an exhaustive list if we come up with other questions. They are.
We want the agency to be as prepared as they can.
Yeah.
So that they can come prepared to answer the questions. And if they can't answer a question, they will be able to say so in advance. And then, as it's been said earlier, if questions get too far out of the scope of what we're doing, it will be the chair's prerogative to say that those questions are out of order. And we'll move on to the next ones. Director, you clear?
Thank you. I
Excellent.
am now very clear on that. So just a couple of items I wanted to walk you through. So since we have last met, I did have the opportunity. So turning to the Chelsea matter, the double homicide and the questions about what the department's role was in responding to this situation. There were some very interesting developments with what is known as a bind over hearing in court. And this is the notion of whether the juvenile defendant will be tried as an adult. And the judge made a ruling right on the first day of the bind over hearing that the confidentiality at issue over these records essentially had to give way to the public ability of both the defendant and the state to deal with the matter. And so essentially you had a good bit of the content of the events coming into the public record. So that is a game changer in terms of what I think we'll be able to, let me put it this way. I'm much more optimistic than in previous discussions with you that there's more that will be able to be in that public report when we get it to you. So it's really a question of just once the judge makes the bind over decision, whether to try as an adult, there's statutory factors. I'm not going to comment on it because it's the judge's decision, but let's just say it goes to adult court. That's all public. And again, there could be a plea, there could be a trial, but just as soon as that's done, we will be there and that will be something. So I just wanted to assure the committee that I'm doing everything in my power to be present. Senator Diamond often talked about in the courtroom, how you can see things going on and you get insights. This was one of those moments that you really, it was a very fascinating moment because there were motions to essentially say, let's keep all this closed, and the judge wasn't having it. So just an interesting dynamic. So we will move along on that just as soon. And again,
Who was the judge?
Judge Charles Dow. District Court sitting as the juvenile court, but by statute, the bind over hearing is actually public. It's very interesting how that goes. So I was right there, had my seat. And just mentioning that because that remains my understanding that just as soon as I can start working on that, committee's expectation, unless I hear otherwise, remains that's a priority. So moving on from that item.
Sorry, Director.
Oh,
Were there any
sorry.
Questions from anyone on the committee about that? Thank you for that update. So you may.
Just wanted to note for the record that members, and it's in your binders, and the person submitted it with the understanding that we'll essentially put this on our documents page. But a caseworker who had testified during the Frontline Perspectives, her name is Stacy Henson Drake. There's a letter in members' binders that talk about just adding a little postscript to what she testified. She was the one, I think we all vividly recall, for those of us who were here, that things like sinking ship and that sort of thing. She said it's still, we're still not there, but we're getting better, or that there's a commitment and there's efforts underway. I don't want to try to put any gloss on that. I just wanted to let you know that in all of my time doing this kind of work, you don't often get a letter like back from someone who's been part of something earlier who actually wants to tell you, and now the rest of it just was very interesting. So I just mention it. I do next want to acknowledge that we have received a letter from Representative Nina Milliken, and the members who were here will recall that Representative Russell White had written to the committee previously, and I know Ms. Betsy Grant is here in the room, and she is asking the committee again to consider tasking OPEGA with a review into some of Ms. Grant's concerns about retaliation by the department. Now, here again, it's in your binders a little further. If you go through all the little binders that have construction paper, I think behind the bright yellow, not the orange, but behind the bright yellow, it is also the case, similar to what we discussed today in the correctional context. Ms. Grant, as is her right, has availed herself of a lawsuit in federal court that is currently pending. I am not here to tell you what the merits of that are or not. I'm simply wanting to make sure the committee has the information. There are at times practical considerations for having an OPEGA review going on at the same time a court matter is going on. Obviously, the most vivid example is Chelsea, where a homicide investigation and prosecution it has to take precedent. Here, I'm not saying it's impossible, but what I'm saying is when folks are represented by counsel, there could be issues of me trying to talk to witnesses, represented parties, and I'm an attorney, and they're represented by attorneys. There can be issues there. There are matters in court. It is up to the committee to decide, as was discussed earlier. I just wanted to make sure you knew that that was there, so that as you consider Representative Milliken's letter, that is understood. This is also a question where the committee can invite, and this is a legislator letter, so it's the same topic, but it's a legislator. And so under our practices, Representative Milliken could be invited by the chairs to come and present it and then have another consideration of the matter. So I just mentioned that. I wanted to acknowledge it for the record, but recognize that that's not happening today, and we'll work through that. I'm happy to stop talking there if there was any minor comment on that.
Thank you, Director. Does any member of the committee have any comment on the matter? It will remain on future consideration. The chair will say that I have just read the complaint. And I think that, again, because complaints that go to court, people are under oath, all sides of the story have to be examined, and judges and or juries deliberate and make decisions. They can also inform us when they make a ruling about what to do. The chair recognizes Representative Perkins.
Thank you, Mr. Chairman. I think that because Representative Milliken is a sitting legislator and she has sent us a letter, I think we should give her the same courtesy we give to every legislator that has sent in a letter and invite her to come present that letter before the committee.
Sounds like a plan. The chairs will take that under advisement and put it on a future meeting. Anything else, Director?
Very briefly, if it's helpful to members and you just want to pluck this right out in the sort of the orange slide, there's just kind of a final accounting for you on all the legislation that occurred. And for those who are departing or those, who want a memento, or those who want to take up the cause again in the next session, I just thought we'd give you a little final accounting of where things landed about issues that were of interest to you
This is great.
and the committee. So you, by all means, just take that with you if you would like, or if you'd like it emailed to you, we're happy to send that.
Please.
Okay, very good.
Yeah, I'll
We'll,
take
we'll,
this
we'll do
and-
both.
yes,
Yes,
please,
and.
Please.
So,
please.
okay. And
Both
then,
and.
yep.
Senator Farren.
Would the director be willing to autograph my copy? Then
I'd
I
be
think-
more than happy.
All right. just-
More than happy. So, very quickly, I think we're literally almost there. So just again, that the Senator Hickman already referenced, the letter went out to Commissioner Clark at DAFS about the email accounts, and we do expect some accounting of the extent to which this is occurring in departments beyond DHHS. Then again, subject to meeting with the chairs and discussing this, there is a tentative date for the next meeting listed as June 17th. We've already heard that there may be matters with the Department of Corrections where we want to come back. So I don't want to get ahead of the chairs, but at least keep that, if you would, June 17th placeholder still in place, because that could well be when we would typically have. It's a third Wednesday is our protocol in the interim. And with that, I'm all out of sub tabs. So thank you again for everything. I hope everyone is having a nice time. I know you have other matters to attend to outside the legislature, but we always appreciate the opportunity to attend to the matters in the legislature throughout the year. And I know that's an extra challenge and burden for the members who are on this committee, and we appreciate it.
Well, this is why we are here. And thank you, Director, and thank you, Ms. Minor, for keeping us all intact. If there are no objections, the Joint Legislative Committee on Government Oversight stands adjourned.